Chapter 2. Preventive Measures. Article 5. Preventive anti-corruption policies and practices. 1. Each state party shall, in accordance with the fundamental principles of its legal system, develop and implement or maintain effective, coordinated anti-corruption policies that promote the participation of society and reflect the principles of the rule of law, proper management of public affairs and public property, integrity, transparency, and accountability. 2. Each state party shall endeavor to establish and promote effective practices aimed at the prevention of corruption. 3. Each state party shall endeavor to periodically evaluate relevant legal instruments and administrative measures with a view to determining their adequacy to prevent and fight corruption. 4. States parties shall, as appropriate and in accordance with the fundamental principles of their legal system, collaborate with each other and with relevant international and regional organizations in promoting and developing the measures referred to in this article. That collaboration may include participation in international programs and projects aimed at the prevention of corruption. Article 6. Preventive anti-corruption body or bodies. 1. Each state party shall, in accordance with the fundamental principles of its legal system, ensure the existence of a body or bodies as appropriate that prevent corruption by such means as a. Implementing the policies referred to in Article 5 of this convention and, where appropriate, overseeing and coordinating the implementation of those policies. B. Corruption. 2. Increasing and disseminating knowledge about the prevention of each state party shall grant the body or bodies referred to in paragraph 1 of this article the necessary independence, in accordance with the fundamental principles of its legal system, to enable the body or bodies to carry out its or their functions effectively and free from any undue influence. The necessary material resources and specialized staff, as well as the training that such staff may require to carry out their functions, should be provided. 3. Each state party shall inform the Secretary General of the United Nations of the name and address of the authority or authorities that may assist other states' parties in developing and implementing specific measures for prevention of corruption. Article 7. Public Sector. Each state party shall, where appropriate and in accordance with the fundamental principles of its legal system, endeavor to adopt, maintain, and strengthen systems for the recruitment, hiring, retention, promotion, and retirement of civil servants and, where appropriate, other non-elected public officials. A. That are based on principles of efficiency, transparency, and objective criteria such as merit, equity, and aptitude. B. That include adequate procedures for selection and training of individuals for public positions considered especially vulnerable to corruption and the rotation, where appropriate, of such individuals to other positions. C. That promote adequate remuneration and equitable pay scales, taking into account the level of economic development of the state party. D. That promote education and training programs to enable them to meet the requirements for the correct, honorable, and proper performance of public functions, and that provide them with specialized and appropriate training to enhance their awareness of the risks of corruption inherent in the performance of their functions. Such programs may make reference to codes or standards of conduct in applicable areas. 2. Each state party shall also consider adopting appropriate legislative and administrative measures consistent with the objectives of this convention and in accordance with the fundamental principles of its domestic law, to prescribe criteria concerning candidature for an election to public office. 3. Each state party shall also consider taking appropriate legislative and administrative measures consistent with the objectives of this convention and in accordance with the fundamental principles of its domestic law, to enhance transparency in the funding of candidatures for elected public office and, where applicable, the funding of political parties. 4. Each state party shall, in accordance with the fundamental principles of its domestic law, endeavor to adopt, maintain, and strengthen systems that promote transparency and prevent conflict of interest. Article 8. Codes of conduct for public officials. 1. In order to fight corruption, each state party shall promote inter alia integrity, honesty, and responsibility among its public officials in accordance with the fundamental principles of its legal system. 2. In particular, each state party shall endeavor to apply, within its own institutional and legal systems, codes or standards of conduct for the correct, honorable, and proper performance of public functions. 3. For the purposes of implementing the provisions of this article, each state party shall, where appropriate and in accordance with the fundamental principles of its legal system, Take note of the relevant initiatives of regional, interregional, and multilateral organizations, such as the International Code of Conduct for Public Officials, contained in the Annex to General Assembly Resolution 5159 of December 12, 1996. 4. Each state party shall also consider, in accordance with the fundamental principles of its domestic law, establishing measures and systems to facilitate the reporting by public officials of acts of corruption to appropriate authorities, when such acts come to their notice in performance of their functions. 5. Each state party shall endeavor, where appropriate and in accordance with the fundamental principles of its domestic law, to establish measures and systems requiring public officials to make declarations to appropriate authorities regarding, inter alia, the outside activities, employment, investments, assets, and substantial gifts or benefits from which a conflict of interest may result with respect to their functions as public officials. 6. Each state party shall consider taking, in accordance with the fundamental principles of its domestic law, disciplinary or other measures against public officials who violate the codes or standards established in accordance with this article. Article 9. Public Procurement and Management of Public Finances. Each state party shall, in accordance with the fundamental principles of its legal system, take the necessary steps to establish appropriate systems of procurement based on transparency, competition, and objective criteria in decision-making that are effective, inter alia, in preventing corruption. Such systems, which may take into account appropriate threshold values in their application, shall address, inter alia, a. the public distribution of information relating procurement procedures and contracts, including information on invitations to tender and relevant or pertinent information on the award of contracts, allowing potential tenders sufficient time to prepare and submit their tenders. B. The establishment in advance of conditions for participation, including selection and award criteria and tendering rules and their publication. C. The use of objective and predetermined criteria for public procurement decisions in order to facilitate the subsequent verification of the correct application of the rules or procedures. D. An effective system of domestic review, including an effective system of appeal, to ensure legal recourse and remedies in the event that the rules or procedures established pursuant to this paragraph are not followed. E. Where appropriate, measures to regulate matters regarding personnel responsible for procurement, such as declaration of interest in particular public procurements, screening procedures, and training requirements. 2. Each state party shall, in accordance with the fundamental principles of its legal system, take appropriate measures to promote transparency and accountability in the management of public finances. Such measures shall encompass, inter alia, a. procedures for the adoption of the national budget. B. Timely reporting on revenue and expenditure. C. A system of accounting and auditing standards and related oversight. D. Effective and efficient systems of risk management and internal control. And E. Where appropriate, corrective action in the case of failure to comply with the requirements established in this paragraph. 3. Each state party shall take such civil and administrative measures as may be necessary, in accordance with the fundamental principles of its domestic law, to preserve the integrity of accounting books, records, financial statements, or other documents related to public expenditure and revenue, and to prevent the falsification of such documents. Article 10. Public Reporting. Taking into account the need to combat corruption, each state party shall, in accordance with the fundamental principles of its domestic law, take such measures as may be necessary to enhance transparency in its public administration, including with regard to its organization, functioning, and decision-making processes, where appropriate. Such measures may include, inter alia, a. adopting procedures or regulations allowing members of the general public to obtain, where appropriate, information on the organization, functioning, and decision-making processes of its public administration, and, with due regard for protection of privacy and personal data, on decisions and legal acts that concern members of the public. B. Simplifying administrative procedures, where appropriate, in order to facilitate public access to the competent decision-making authorities. And C. Publishing information, which may include periodic reports on the risks of corruption in its public administration.
Article 11. Measures relating to the judiciary and prosecution services. 1. Bearing in mind the independence of the judiciary and its crucial role in combating corruption, each state party shall, in accordance with the fundamental principles of its legal system and without prejudice to judicial independence, take measures to strengthen integrity and to prevent opportunities for corruption among members of the judiciary. Such measures may include rules with respect to the conduct of members of the judiciary. 2. Measures to the same effect as those taken pursuant to paragraph 1 of this article may be introduced and applied within the prosecution service in those states parties where it does not form part of the judiciary but enjoys independence similar to that of the judicial service. Article 12. 1. Each state party shall take measures in accordance with the fundamental principles of its domestic law to prevent corruption involving the private sector, enhance accounting and auditing standards in the private sector and, where appropriate, provide effective, proportionate and dissuasive civil, administrative or criminal penalties for failure to comply with such measures. 2. A. Measures to achieve these ends may include, inter alia, promoting cooperation between law enforcement agencies and relevant private entities. B. Promoting the development of standards and procedures designed to safeguard the integrity of relevant private entities, including codes of conduct for the correct, honorable and proper performance of the activities of business and all relevant professions and the prevention of conflicts of interest, and for the promotion of the use of good commercial practices among businesses and in the contractual relations of businesses with the state. C. Promoting transparency among private entities, including, where appropriate, measures regarding the identity of legal and natural persons involved in the establishment and management of corporate entities. D. Preventing the misuse of procedures regulating private entities, including procedures regarding subsidies and licenses granted by public authorities for commercial activities. E. Preventing conflicts of interest by imposing restrictions, as appropriate and for a reasonable period of time, on the professional activities of former public officials or on the employment of public officials by the private sector after their resignation or retirement, where such activities or employment relate directly to the functions held or supervised by those public officials during their tenure. F. Ensuring that private enterprises, taking into account their structure and size, have sufficient internal auditing controls to assist in preventing and detecting acts of corruption, and that the accounts and required financial statements of such private enterprises are subject to appropriate auditing and certification procedures. 3. In order to prevent corruption, each state party shall take such measures as may be necessary, in accordance with its domestic laws and regulations regarding the maintenance of books and records, financial statement disclosures and accounting and auditing standards, to prohibit the following acts carried out for the purpose of committing any of the offenses established in accordance with this convention. A. The establishment of off-the-books accounts. B. The making of off-the-books or inadequately identified transactions. C. The recording of non-existent expenditure. D. The entry of liabilities with incorrect identification of their objects. E. The use of false documents. And F. The intentional destruction of bookkeeping documents earlier than foreseen by the law. 4. Each state party shall disallow the tax deductibility of expenses that constitute bribes, the latter being one of the constituent elements of the offenses established in accordance with Articles 15 and 16 of this convention and, where appropriate, other expenses incurred in furtherance of corrupt conduct.
Article 13. Participation of society. Each state party shall take appropriate measures within its means and in accordance with fundamental principles of its domestic law, to promote the active participation of individuals and groups outside the public sector, such as civil society, non-governmental organizations, and community-based organizations, in the prevention of and the fight against corruption and to raise public awareness regarding the existence, causes, and gravity of the threat posed by corruption. This participation should be strengthened by such measures as A. Enhancing the transparency of and promoting the contribution of the public to decision-making processes. B. Ensuring that the public has effective access to information. C. Undertaking public information activities that contribute to non-tolerance of corruption, as well as public education programs, including school and university curricula. D. respecting, promoting, and protecting the freedom to seek, receive, publish, and disseminate information concerning corruption. That freedom may be subject to certain restrictions, but these shall only be such as are provided for by law and are necessary. 1. For respect of the rights or reputations of others. 2. For the protection of national security or order public or of public health or morals. 2. Each state party shall take appropriate measures to ensure that the relevant anti-corruption bodies referred to in this convention are known to the public and shall provide access to such bodies, where appropriate, for the reporting, including anonymously, of any incidents that may be considered to constitute an offense established in accordance with this convention. Article 14. Measures to prevent money laundering. 1. Each state party shall institute a comprehensive domestic regulatory and supervisory regime for banks and non-bank financial institutions, including natural or legal persons that provide formal or informal services for the transmission of money or value, and, where appropriate, other bodies particularly susceptible to money laundering within its competence, in order to deter and detect all forms of money laundering, which regime shall emphasize requirements for customer and, where appropriate, beneficial owner identification, record-keeping, and the reporting of suspicious transactions. B. Without prejudice to Article 46 of this convention, ensure that administrative, regulatory, law enforcement, and other authorities dedicated to combating money laundering, including, where appropriate under domestic law, judicial authorities, have the ability to cooperate and exchange information at the national and international levels within the conditions prescribed by its domestic law and, to that end, shall consider the establishment of a financial intelligence unit to serve as a national center for the collection, analysis, and dissemination of information regarding potential money laundering. 2. States parties shall consider implementing feasible measures to detect and monitor the movement of cash and appropriate negotiable instruments across their borders, subject to safeguards to ensure proper use of information and without impeding in any way the movement of legitimate capital. Such measures may include a requirement that individuals and businesses report the cross-border transfer of substantial quantities of cash and appropriate negotiable instruments. 3. States parties shall consider implementing appropriate and feasible measures to require financial institutions, including money remitters, A. To include on forms of the electronic transfer funds and related messages accurate and meaningful information on the originator, B. To maintain such information throughout the payment chain, and C. To apply enhanced scrutiny to transfers of funds that do not contain complete information on the originator. 4. In establishing a domestic regulatory and supervisory regime under the terms of this article, and without prejudice to any other article of this convention, states parties are called upon to use as a guideline the relevant initiatives of regional, interregional, and multilateral organizations against money laundering. 5. States parties shall endeavor to develop and promote global, regional, sub-regional, and bilateral cooperation among judicial, law enforcement, and financial regulatory authorities in order to combat money laundering.